Ready for the dictation? Start. This appeal is filed against the final judgment and order dated 29/10/2018 passed by the High Court of Judicature at Allahabad in an application filed under Section 482 of the Code of Criminal Procedure 1973, hereinafter referred to as the Code bearing number 33965 of 2018, whereby the one single judge of the High Court dismissed the application filed by the appellant herein stop. Stanza. Few facts need mention herein below to appreciate the short controversy involved in this appeal. Stop. Stanza. By impugned order, the single judge dismissed the appellant's application filed under Section 482 of the Code, wherein the challenge was to set aside the charge sheet dated 18/9/2015 and 22/9/2017 framed by the Additional Sessions Judge Fast Track Court Number 3, Muzaffarnagar, arising out of Sessions Trial Number 798 of 2017, State versus Monu under Sections 420, 498A, 323, 376, 506 of the Indian Penal Code 1860, hereinafter referred to as IPC, and Sections 3 and 4 of the Dowry Prohibition Act 1961, Police Station, Mahila Thana, District, Muzaffarnagar. Stop. Stanza. The short question which arises for consideration in this appeal is whether the High Court was justified in dismissing the appellant's application filed under Section 482 of the Code. Stop. Stanza. Heard learned counsel for the parties. Stop. Stanza. Having heard the learned counsel for the parties and on perusal of the record of the case, we are constrained to set aside the impugned order and remand the case to the High Court for deciding the appellant's application, out of which this appeal arises afresh on merits in accordance with law. Stop. Stanza. On perusal of the impugned order, we find that the single judge dismissed the application by passing the following order. Stop. I have gone through the impugned order and I find that there is no illegality or perversity either in the eye of law. Stop. I do not find any good ground to interfere with the order impugned. Stop. We are unable to know, much less to appreciate even the factual metrics of the case after reading the impugned judgment. Stop. Stanza. In our view, the single judge ought to have first set out the brief facts of the case with a view to understand the factual metrics, and then should have examined the challenge made to the proceedings in the light of the principles of law laid down by this court on the question involved, with a view to record the findings on the grounds urged by the appellant as to whether any case for interference therein is made out or not. Stop.